Once I saw that Ms. Brady's name had signed the warrant that we never received that said she approved it.
Yes, I understand. My name is on the warrant 7 months ago.
At this point, this is probably one of the most egregious discovery violations I've seen, as keeping information from the defense. And I know this court has seen a lot of them from this office.
All right. The court will call 25 CR 3205, people of the state of Colorado v. Isaiah Marquez, who's present, and counselor here. We're scheduled for a jury trial today. Entries of appearance.
Julia Brady and Ricardo Bravo for the people.
Amanda Miller and Natalia Alvarez on behalf of Mr. Marquez, who appears with us at the table from in custody.
All right. I noted in the, I think I found it in the, oh, it's in the regular file now. There's a motion to dismiss or for sanctions that was filed. Anything you'd like to add?
So one thing I would add is that in discovery, there is a report from Detective Crook about a warrant that she signed on January 16th, 2016. However, this warrant was written the same day, approved, signed by the same judge as the one that we never received in discovery. My concern mostly is the records that the district attorneys have made and how they have impeded our investigation throughout this case by keeping this information. Mainly, once I saw that Ms. Brady's name had signed the warrant that we never received that said she approved it, I think given that it's been known about, that apparently the detective discussed this information and we were repeatedly told the phone hadn't been searched, that we couldn't have the phone in case they did need to search it. At this point, this is probably one of the most egregious discovery violations I've seen, as keeping information from the defense. And I know this court has seen a lot of them from this office. I think that a dismissal is the only thing that is appropriate in this case. We don't have those messages for trial today because we were prevented from getting them, and so they are effectively destroyed. Under Great House, this would be a dismissal. It is the state's, it's been in the state's possession since November 17th. It is their actions, their words, their records as officers of the court that have led this court and the defense down the wrong direction with trying to get these messages. I don't think there is any other remedy that would make this right, especially to enforce the truth-seeking process of a trial, which is what it is. And the DAs in this case have refused to find the truth in the case. I am asking for a full dismissal of this matter due to this egregious discovery violation and the exculpatory nature of the evidence that has been effectively destroyed.
Well, just remind me exactly what the evidence that you're referring to.
Yes. So it appears that on January 16th, a warrant was written or assigned to search the phone. And a detective tried to search the phone. We had none of this information. What had happened is when we got...
That really wasn't my question. My question was what evidence was purportedly destroyed?
This would have been the Facebook messages that were in the phone that we can't get to. So effectively, they're
between who and who?
So these would be the threats from Mr. Wells to Mr. Marquez. And in my supplemental motion, I highlighted how the prosecution has known about the exculpatory alleged threats since November 15th of 2025. And I think that also goes into why they wrote this warrant that we didn't know about. Those text messages go to a defense in this case to show Mr. Marquez's mental state. They would have gone to negotiations. If I would have known that the district attorney had been already tried to search the phone, I would have made a different record for us to have the phone released to us, which could have resolved this issue that they objected to, saying that maybe they'll want to search the phone, which they already have attempted to. The way that they did it by trying to go around the passcode.
Right, you're going way past what I asked.
Okay.
All right, for the people.
Yes, I understand my name is on the warrant as approved to form 7 months ago, back in January. I did not keep track of the status of the warrant. My assumption is the detective failed to write a report at the time because nothing was searched or obtained or nothing was seized. I disagree with that procedure. I believe that a report should be written for any efforts or anything that a detective or officer does on a case. But once we found out about that detective's efforts to try to get into the phone after obtaining a valid search warrant, we immediately asked her to write a report about that and disclose it to defense.
When and how did you find out about this?
We, during our trial prep, and going through discovery, I realized that I did remember that there was a warrant that was issued, and I wanted to follow up with her.
Well, I get you must have remembered. We just had a hearing on Monday, so I assume you remembered between Monday of last week and today.
I did, and the phone. The issue with the phone. And the defense's position on this exculpatory evidence that apparently is on the phone did not become apparent to the people until the pretrial conference. There was no discussions between the defense and the people of the phone or what they believed to be on the phone prior to that. There was nothing searched on the phone. There's no destruction of evidence. This is a very different situation than if the detective actually did extract and dump the phone and was holding on to this evidence, but that is not the case here. Mr. Marquez's due process rights are not violated in any way. And so the only prejudice that the people could think of is that the defense maybe planned on cross-examining these officers, that there's no warrant to search the phone, that it could have held this evidence, and that there was a sloppy investigation. That is the only prejudice that I could really think of for the defense. We're not contesting that this is not a late disclosure. It is a late disclosure. Additionally, after the defense could not get into the phone, the people offered to dump that phone for them, me not knowing that the detective had already tried, and they did not want to proceed that way.
And is the status still he's not going to be here?
He is not going to be here, and he is not under subpoena.
All right. Anything else, Ms. Miller?
We did have conversations about these messages and negotiations. It's affected everything we've done up to this case until now. They did know about it. She's approved the warrant. I don't think there's much else we can say.
The court, based upon the new statutory provision about inspection of evidence, and typically that motion needs to be filed 35 days before the trial. It was filed late, so we did a hearing. It was kind of a hearing and kind of a evidence review sort of thing where the cell phone that allegedly had threatening messages from Mr. Wells was given to the defense. We did have a detective from the Commerce City who is present just to make sure that nothing untoward happened. What I learned afterwards, and I'm probably a little off on this, is that the phone, based upon it being stored or whatever, the Face ID and things like that just didn't work. So defense counsel was informed from the Commerce City detective that the only way to get that information would be to basically do a factory reset on the phone and then grab it from the cloud. I suppose somewhat coincidentally, my son broke his phone and we got a new one from insurance. And he already turned in his old phone. And he was able to, with the new phone, get everything back on his phone from the cloud. The one thing about either sanctions or suppression, and SCOTUS has mentioned this many times, is that that should not be a court's first instinct but the last resort. So this is my remedy. The oral motion that was filed under Rule 41 on behalf of Mr. Marquez is granted. You can have the phone. We'll continue the matter till the 24th, and we'll see what's there and what's not, and then I can make a more appropriate decision on sanctions, perhaps.
Just to clarify, is the court ordering the phone be released?
Exactly.
Okay. And then,
That gives you, not quite a couple weeks, but at least time to try to do what my son did over the weekend.
yes. And that, and that is one thing that we were hoping to do. And with the restore was essentially if it is in the iCloud. So with the destruction, that was for, one, I don't know what happened on the phone, if anything, but also just for, technically for today, it would be destroyed. But if it's still on there, of course, we want that. The other issue would be if we were able to argue bond for Mr. Marquez, because it is difficult to do this while he's in custody and to get this information, especially without service in the jail, really good phone service.
Well, it looks like you have an investigator that can relay information to you.
Okay.
So I'm not going to mess with the bond. If I was continuing it longer than I am, I probably would.
Okay.
But it's a couple of weeks. It's within speedy by a little bit. And what I will do is ask one of the two of you folks to, it doesn't have to be a work of art, but at least has to inform the Commerce City Police Department about what my order is.
And just so everyone's aware, the phone is booked in evidence at our office, given that we offered to defense to extract the phone and we have some technology there. So we just kept it there.
Okay, well, I guess the order needs to say that as well.
Okay, so it's at the DA's office.